just going to briefly introduce our speaker and then let Rick get on with it. Dr. RickLines. Rick is the Executive Director of Harm Reduction International. He's been working at harm reduction, I think, since around 2007.
With that organization?
Yeah, with that. Previously, he's worked in the area of harm reduction for many years, back in the 90s, where he was working quite a lot on the issue of HIV in prisons and various needle exchange programs and so on. He's been doing that for many years now. And not just with organizations, but also as a recognized expert. He's been an advisor to a number of UN agencies on these topics.
Not that they take my advice.
Sorry?
Not that they take my
Oh,
advice.
they don't take your advice? He tries. He tries. But those of you that now study human rights are going to get used to that. You try. In addition to that, Rick has been working not just on the specific issue of harm reduction, but also more generally in the field of human rights and drug policy. And he's actually just recently been awarded a PhD for his research in that area, which is now turning into a book. And Rick, together with a colleague, Damon Barrett, are the co-founders of the International Center on Human Rights and Drug Policy. And this is the first and really the only NGO that focuses on human rights and drug policy and does some really important work in this area. The Center on Human Rights and Drug Policy is now hosted at the Human Rights Center here at the University of Essex. It's been that way for, I think it's three or 4 years now. If I remember correctly, it was a conference in China where Rick and I were sitting in a hotel bar in Beijing and discussed bringing the Center on Human Rights and Drug Policy here to Essex. And I think that's worked out very nicely. We've run a few projects together from here, all sorts of areas, including various debates that we held around the world on topics in human rights and drug policy, promoting teaching in this, research projects. We have a number of projects going on right now with Julie, some of you will know, leading work here at Essex on this, and some of you I know are in the clinic working on 2 projects we have at the Human Rights Center clinic, partnering with the Center on Human Rights and Drug Policy. And there's loads of areas that, when we talk about human rights and drug policy, loads of areas that the two cross over. Rick's going to talk more generally about how to look at the issue of human rights and drug policy, how to actually combine when you're trying to research, when you're trying to think what are the links and how to address this. Are we all right there?
Yeah, but it's fine.
Okay. So he's going to do this with a combination of a general approach and looking specifically at 1 or 2 issues. I'm going to hand over now to Rick, and we'll, I think, be around up to around half an hour presentation, and then we'll have time for some questions and discussion.
Great, thank you very much, John. We're just trying to find a quick little video here, which I neglected to find beforehand. We'll come in the middle of the presentation. Basically, what I wanted to try to do this afternoon was a couple of things. Okay, there it is. So we're ready for when it comes in. Thank you. I'm going to talk about the intersection between international human rights law and international drug control law. But what I want to try to do is something different for me, is actually give a bit of guidance to you for people who might be interested in researching these issues about how you actually go about researching international drug control law issues. What are the sources of law? What are the things you can look at? Because as we'll see, I think there's a lot of challenges that we face in trying to look at this particular area. And I'm going to try to do this not in a very dry methodological sense, but to try to do it through explaining how I went about researching one particular topic, which is compulsory drug detention centers, and looking at the human rights implications involved in those. Looking at human rights and drug control issues is, maybe a bit unique to some areas of human rights endeavor, because what we were dealing with is 2 parallel bodies of international law. Probably, maybe a lot of you are not even familiar with the fact that there are international drug control conventions I know many people I talk to, even law professors, have no idea that there are international treaties on drug control. But they're very widely ratified, and they have significant and direct impact on the drug laws of almost every country in the world. So what makes drug control and human rights interesting is that in many cases the human rights abuses which we're concerned about are the result of how states seek to enact or fulfill the obligations in a parallel body of international law. So it means that we have to kind of interpret our way and search our way through two different bodies of work in order to try to come to, I think, some detailed conclusions about protecting human rights within the context of drug control. To start with a quote, this is a quote from Professor Norbert Gilmore, who's a professor at McGill University in Montreal. This is from an article that he wrote in 1996, one of the very first articles on human rights and drug control. And he wrote that little has been written about drug use and human rights. Human rights are rarely mentioned in drug control literature, and drug use is rarely mentioned in the human rights literature. That was almost 20 years ago, and that statement still largely holds true. There is a growing body of research and publishing on issues around human rights and drug control, but it still would rank the subject as barely a footnote in the broader kind of human rights library. Some of that work is very, very good. Some of it is very, very bad, as we would expect in any kind of area we might look at. I think what's also interesting when you look at some of the work around drug control is that drug control is a terrain of political contest between states, between actors within states. So a lot of what we might see being reflected in the literature is very often derivative of particular points of view. That doesn't necessarily make it bad or incorrect, but it does perhaps influence what goes on. And in some cases, I think it does make it bad and incorrect, but hopefully that would stand out even to a layperson reading it. But what I want to try to give today is some examples or approaches to what I would recommend for trying to do good comprehensive work in this particular area. Because as I talked about this afternoon, the interesting thing about drug control to me and why I work in this area, even though I really have no particular interest in drug control as a topic, is because drug control and drug policy intersects with a wide variety of human rights issues around the world. You can scratch almost any particular area of human rights you might be interested in, and you can almost always find an area where drug laws or drug control, drug policy has a relationship to it. So I really work in the area of drug law, not because I'm particularly interested in drug control or drug policy, but because bad drug policy and bad drug control can have really bad impacts on human rights protections. So basically, there's a number of challenges, I think, confronting people like us who are doing research in human rights and drug policy, which makes it a bit different than maybe some other areas. The first is actually understanding drugs, drug use. Drugs, obviously, if you went to a library, you could probably fill an entire area of a library with medical and health research on drugs, very little on drug control law, and very little on drugs and human rights. But so much of what's written about drugs, so much of what underpins drug law, ostensibly is related to the health impacts of drugs. But unfortunately, very often those health impacts have been exaggerated, the risks are exaggerated, the stigma related to drugs is very severe, the risk of drugs as an international menace, to use the words that come up, is overstated. So this kind of context of demonizing drugs and demonizing drug use and drug users infuses the whole area. And that's true going back 100 years. I mean, international drug control law, as treaty law, dates back over 100 years at this point in time. So that's something we have to deal with when we're looking at human rights issues, because obviously we need to look at evidence when we look at human rights. So we have to understand drugs, which becomes an additional challenge to us. Again, we're dealing with two different international legal regimes. So as well as we might know international human rights law, doing, I think, high quality work and comprehensive work in this area also requires us to have an understanding, at least a basic understanding of international drug control law, at least as it affects the particular area of human rights we're interested in. Again, the dearth of literature in this area overall, particularly the dearth of high-quality literature, makes it more difficult to do research, specifically to do research that's not derivative. I mean, even the work that is done in the area of drug control and human rights tends to be done on a very small number of issues. So that really leaves a kind of a couple of options for people who are students or are doing research on this, is either you kind of are left replicating or regurgitating the work that's already been done, which is probably not that satisfying to you as a scholar, or you need to kind of dive in and put your own spin and your own human rights analysis on a new area that hasn't been done. And that's the challenging part that I hope I can give some advice on today, which is, again, the challenge of doing non-derivative work. And Julie's doing some of this work now in the area of shooting down drug traffickers' airplanes, right? So, I mean, a very interesting topic. I don't think there's been much of anything written about, but again, that's a matter of how do you apply other areas of law to the specific challenge of drug control and specific logic of drug control. So, I mean, the question I want to try to address over the next sort of 20 minutes is how do we go about doing that high-quality work in an area of international law, whether we're looking at essays, whether we're looking at journal articles, theses, blog posts, what are we looking at in terms of this particular area? So, the first thing I want to familiarize you with, which will be key if you want to do this, is the key primary sources. I mean, imagine a lot of you are familiar with what would be some of the key primary sources for human rights law. Right? What are some of the key sources we do for human rights law?
Conventions.
Treaties, conventions, obviously, first step. Anything else? What are the main, so if you're doing your essay on a human rights issue, what are the main sources you look at?
Cases.
Sorry?
Law cases.
Yeah, law cases, jurisprudence, absolutely. There's a number of other areas we might look at the work of the treaty bodies related to the, that are, work out of the conventions themselves. We might look at the work of the High Commissioner for Human Rights Office. We might look at the work of the special procedures, the special rapporteurs. We might look at regional instruments and parallel bodies and regional systems. So for those of us working in human rights, we're fairly, we know where to go for those kinds of things. And one of the ways we can approach the work, and I think a central area of approaching the work, is to start with those human rights sources and see if and when they talk about drugs. That's fairly straightforward. We can all do that. Probably the more difficult thing, I should lie, it's not difficult. It's actually very easy. The less obvious thing, probably to human rights scholars, is where do you go to look for drug control information? Well, we do the same thing. We start with the International Drug Control Conventions. The first one from 1961, the Single Convention on Narcotic Drugs. This primarily regulates the cultivation, production, trafficking, use of plant-based narcotics, opium, coca, and cannabis primarily. It's the 1971 Drug Control Treaty, the Convention on Psychotropic Substances, which does kind of the same job, but for synthetically produced drugs, laboratory-produced drugs, so hallucinogens, amphetamines, barbiturates, those types of things. And the 1988 Convention Against Illicit Traffic, which is the primary penalization convention. But when we're looking at sources of law in international drug control law, this is where we begin. And we can go through these conventions, and we can see where human rights might intersect in any one of those things. And there's lots of areas. I mean, for people who are interested in criminal law, international criminal law, prison issues, we have a lot of information on a lot of articles in there that relate specifically to those. People who are interested in indigenous rights, we have aspects of indigenous rights that are reflected or affected by drug control specifically. So there's any number of particular, right to health obviously is sort of infused throughout. So there's very key areas we can go to in key treaty-based sources. But we have other sources beyond that we can look at. This is the 1912 Opium Convention. This is the very first multilateral drug control treaty. For my own work, I'm actually quite fascinated in going back to the previous drug control regime. The modern regime is actually based upon the League of Nations treaty regime. I mean, this treaty actually predates the League of Nations. But depending on what issue you're looking at, something I did a lot for my thesis was actually looking at the law that actually came before the modern regime and how the modern regime and the grows out of those conventions. So that's something you might look at as well. And again, we have similar relationships to human rights that we can be found in those things. They won't use the words human rights. That's kind of the challenge of how you apply that to your particular area. But this is one key area to start with looking. Another area is what we call the official commentaries, which are basically books like this. I'm going to pass that around. These are basically books produced by the United Nations, which are exactly what they say, the official commentary on the relevant convention. They're all about 400 or 500 pages long. You don't have to read them. They're all broken down by the article you're looking at. So if you're interested on the article on penal measures related to drugs in the 1961 convention, you can just go to that, and that'll give you some commentaries, some opinion on how you would interpret that, maybe a bit of the drafting history. But again, this helps to give additional background information, which is often useful. We see this in human rights quite a bit, where we refer back to the travaux preparatoires in trying to see how a particular wording of an article came to be decided. There's exactly similar processes that go through all treaties, and part of that is reflected in the commentaries to the 3 treaties, and also the commentary to what we call the protocol. The 1961 convention was updated, essentially, in 1972. There's a commentary on that process. But going beyond that, if you want to dig even more deeply, we have the official drafting histories. And this, again, this is something that I refer to quite a bit. If you want to look at the debates at country level, what the member states were saying in order to decide on that specific language, what that specific language meant or didn't mean at that particular meeting, this is where you go to. And again, this is exactly identical to the travaux that you would see for human rights treaties and can be used in exactly the same way. I should say all of these documents are available on our website, so you don't have to go looking for them. And they're all searchable by keyword, which actually, I lie. The commentaries aren't searchable by keyword, are they?
You can search the PDF.
Can you? Okay, mine aren't. Oh, well. But these certainly are. And again, you can see here, this is just an example of who's this? Canada, the United States, the United Arab Republic, and the Netherlands arguing back and forth about the drafting of a particular provision. This particular bit down here is what I'm going to be talking about today, which was draft Article 47 in the 1961 Treaty on the Treatment of Addicts, as it was called at the time in the old language. Other key sources outside of the legal texts themselves, again, very similar. Again, the drug control regime is a parallel regime within the United Nations. So we have various committees and bodies that do work on drug control. The United Nations Commission on Narcotic Drugs is the main political body. So they have meetings every year, they pass resolutions, they have minutes of their meetings, they have debates. Sometimes those debates even revolve around human rights in recent years. So that becomes useful. The Economic and Social Council of the United Nations oftentimes talks about drugs. They at least receive the reports of the Commission on Narcotic Drugs. The UN General Assembly has passed over 100 resolutions on drugs since its first session. So again, these are other areas you can look at, not necessarily areas of hard law, but you can fill in some of the gaps that we might see around approaches where drugs and human rights intersect. The International Narcotics Control Board is the treaty body that oversees the 3 drug conventions. They put out an annual report, which is available online. Might not be that useful. The International Narcotics Control Board is typically a very conservative body, not very human rights friendly, but that doesn't mean that their work's not useful if you want a foil to sort of show an alternative approach to what often we might see as a human rights-based approach. And then various UN policy documents. I mentioned the UN Office on Drugs and Crime, which is the Secretariat, the High Commissioner for Human Rights, the World Health Organization. Any number of UN agencies would have relevant policy positions. So what does all that mean for issues? I'm going to be talking about the issue of compulsory drug detention. Compulsory drug detention is essentially, we see it in quite a few countries in Asia, it's growing in Latin America, It's based upon a US model, essentially, that was exported to other parts of the world, which is basically about rounding up people who are drug users or are suspected drug users, putting them in mass detention camps for re-education and treatment purposes. These camps have been up to about 500,000 people detained in various countries around Asia, India, as I say. There's a number of them being documented in Latin America now, being run by sort of Christian orders around the state. But many of the same issues of inhuman degrading treatment, arbitrary detention, right to health issues being exposed there as well. This is what I have the video about. What happened with this, Julie? The video is only 1 minute long, so it's very nice. This is a video that Human Rights Watch. The sound is better. Anyway, you can see the pictures of it. Sorry, we should have done this before. We had to pass before. Anyway, you just play without the sound. You can see the pictures of the camps. This is Joe Amon, who's the head of Health and Human Rights at Human Rights Watch. This is a particular camp in Laos. It's only a minute long, so. But you get a sense here of some of the conditions inside the camp. Essentially what happens is people are rounded up. Sometimes they're turned in by their families, sometimes the police bring them there directly. And depending on the country, people can be locked up for numbers of years, actually, without any charge, without any due process, without any ability to be released. Again, all under the guise, supposedly, of providing drug treatment. Although Human Rights Watch has documented in many countries, we see forced labor. As I said, we see various kinds of human rights abuses, let alone the overcrowding and inhumane conditions that are obvious from some of those pictures. I'll really switch to this one. So anyways, the questions to consider here, when we're looking at this particular aspect, is what does international human rights law say about this kind of scenario? What does international drug control law say about this kind of scenario? And then how do the two regimes sort of cross over or engage one another on these particular issues? What can we learn from the engagement between those two regimes to try to come to some sort of conclusion about the human rights issues and the human rights solutions at play? Obviously, an initial starting point is Article 9 of the International Covenant on Civil and Political Rights, the right to liberty and security. We talk about people being arrested, detained without charge, detained without due process. And we know that the prohibition of arbitrary detention, which emerges from the right to liberty and security, creates a number of safeguards that have to be in place. Arrest or detention that must be prescribed by law. Individuals must be informed promptly of the charges against them or the reason for their detention. Individuals must be brought promptly before a judge or some sort of arbiter in order to challenge their detention. So there's a number of important safeguards that clearly aren't in place in these particular settings. When we look at travaux for the drafting of Article 9, it also sort of talks about arbitrariness being not only linked to lawfulness or unlawfulness, but also with arbitrariness is also means incompatibility with the principles of justice or the dignity of the human person. So it's broader than just illegal detention. The Human Rights Committee, of course, which is the treaty body that oversees the covenant, has also said that we shouldn't narrowly look at arbitrary detention as being detention against the law, but also has to be interpreted broadly to include elements of inappropriateness or injustice or the lack of predictability related to when people are rounded up or what kind of detention they can find themselves in. I talked about some of the literature that's available on this topic. I said some of it's good, some of it's bad. This is a particular article that I think falls into the second category, published in Human Rights Quarterly a few years ago, but it talks about, it has an article in fairness, particularly critiquing some of the work of my colleagues on this particular issue. And what the author talks about in sort of challenging some of the work of Human Rights Watch and others, he says that the reality of drug addiction is that it destroys or at least suspends the free will of the addict. By taking into account the varying individual degrees of addiction, the general situation of the addict is one who is, to some extent, consistently under the influence of drugs. It is disingenuous to pretend that the decision not to undergo treatment is an entirely free one. The situation is fundamentally different from the individual who, for religious reasons, chooses not to undergo a particular treatment. Decisions made under the influence of drugs are not decisions of free will, and to base one's arguments on the premise that it is so is to come dangerously close to arguing that there is a right to abuse drugs. Now, how this article actually got into Human Rights Quarterly, I'm not really sure. So, because anything in that, are you concerned by anything you see in that paragraph? I should mention this article was written by an Essex alumni.
No, you didn't have to mention
It was before your time, man.
Does he at least have many, like, is he a doctor or something, a psychologist? He's just.
No, he's like us. He's a human rights person. I mean, there's interesting things in here that jump out immediately. I mean, this whole question around free will, I think, is quite an interesting one, which we sort of thought right away when the article came out in 2009. So if you're saying that decisions of people under the influence of drugs are not free will, that's actually, there's a lot that comes out from that. So are you suggesting then that people aren't criminally responsible, for example, if you're under the influence of drugs? You don't have free will. I mean, to take it a step further, this is the constant, rape defense for men who are drunk. It's like, that wasn't me, I was drunk and I didn't know what I was doing. So when there's those questions, besides the fact that people who use drugs can and do make decisions all the time about themselves and their lives and their health. Those of us who consume alcohol would know that. It's like, well, we might be drunk, but it doesn't mean I've lost my free will. I know what I'm doing, even though I might be intoxicated. The other thing that I always laugh about on this one is that last line. To base one's argument on this premise is to come dangerously close to arguing that there's a right to abuse drugs. Now, I don't actually support the idea of a right to use drugs. I don't think it's a sensible right to try to enshrine. I think there are arguments that can be made about right to privacy as it intersects with that. But I'm not a person who supports the right to use drugs, but as a concept. But I don't think it's dangerous to argue it. People do argue it. And some thoughtful people argue it. I don't think the argument is dangerous to make. I might disagree with it sort of intellectually, but it's not a dangerous argument. Anyway, but this is some of the sort of background, and this gets into that sort of stigma I was talking about at the beginning that influences some of the literature. Is how do you pick apart sort of the stigmatization that goes along with that and try to get to some clear guidance. So when we get into human rights law, we said general arbitrary detention. We can look at what does human rights law have to say about human rights and detention for drugs or consent to treatment for drugs. There's actually a fair bit. The Working Group on Arbitrary Detention specifically talks about, again, their term drug addicts, which isn't a word I would use, a term I would use, but people who use drugs as being a particularly vulnerable group to having to being deprived of liberty arbitrarily. So the Working Group on Arbitrary Detention has specifically talked about the vulnerabilities of this population. Some of the UN human rights mechanisms have used the right to health and also the prohibition of inhuman and degrading treatment to sort of engage this particular issue. The special procedures on health and torture have both talked about people who use drugs as being particularly vulnerable and commented about these particular kinds of camps as being a violation of human rights. So we do actually see not only general human rights law about arbitrary detention, but we see it applied to drugs. And there's specific jurisprudence from the European Court on Human Rights, which is actually quite fascinating, which we can talk about later if anyone has any questions. So the main question then, and this gets back to that section from that article, which is why I pulled it up, is there something unique about drug use or drug dependency or drug addiction that means these normal human rights standards are somehow lessened or should be looked at differently? And this is where we start to get into looking at what international drug control law says. And this is, again, the part that I would say adds the additional, as a scholar or as a researcher, adds the additional level, I think, of flavor to the kind of research we might be doing. And again, we can look at the first drug control convention, the UN, the 61 convention. Article 36 has a specific article on drug treatment. It's the first time an international drug control treaty ever created a state obligation to provide drug treatment. So you could argue, well, the state has an obligation to provide drug treatment, so that therefore there's a conflict. Yes, there's issues around right to consent to treatment, but at the same time, the state is mandated in some way to provide treatment under international drug control law. What's interesting, when you go back into the drafting history, those official records about the drafting of Article 36, is there was actually specific arguments about enshrining within the convention compulsory detention, driven by the United States. I said those camps in Asia and Latin America are driven by a specific American approach to drug treatment. This was the quote from the US representative drafting the 1961 convention on this topic. It said, "Treatment and liberty has failed wherever it's been tried." Essentially, the only way you can deal with drug treatment is to lock people up involuntarily. And there was actually significant debate about this, where the US was trying to have enshrined within the treaty that compulsory detention in closed settings, which I think is the term, compulsory treatment of drug addicts in closed settings should actually be the international legal norm for addressing drug treatment. Now this was actually, in the end, rejected when we came to, actually Article 38, sorry, not Article 36, where the actual agreed language was establish adequate facilities for the effective treatment of drug addicts. I should add, this is actually the old language. I mentioned in 1972 there was a protocol kind of updating parts of this. So this article has totally been rewritten in what you would see. If you went online and downloaded the treaty now, you wouldn't see this. But this is actually the language they were talking about when they debated in that thing. But in fact, the modern language actually removes any reference to treatment modalities at all. So what do we conclude by comparing these two elements? On the one hand, we know that compulsory drug detention en masse is a violation of international human rights law. That was very clear from the first book. But we also know it's not mandated under international drug control law. Not only is it not mandated, it was specifically debated and rejected. So therefore, we actually see, rather than the two regimes being in conflict, there's actually broad consensus if you actually pick apart what the regimes say. In that context, then, drug use or drug dependency cannot be considered a legitimate limitation to the right to liberty and security or consent to treatment in those particular cases. And again, the actual European Court of Human Rights case talks specifically about that, but I don't have time to go through it. I think hopefully this sort of shows the value of doing this kind of integrated analysis, bringing the two regimes together. Because I think the human rights side gives a certain flavor to it, but I think the problem that we always run up against is people assume that, oh, well, we're doing drug control work, by, we have to balance drug control with human rights, and in that analysis, drug control trumps human rights. This is an example, I think, when you actually do the research and go into the sources, you can see that actually the human rights norms are largely supportive of what the drug control language would be, and there actually isn't any conflict. So to suggest that there is actually legally incorrect. I think it shows the value of using all the sources and not relying on a single regime. It makes your arguments stronger. I think it makes them more interesting to read. When you write about drug control law, no one knows about it, so I think that actually gives your work a bit of an extra bit of attractiveness to a reader. And it's an example of the importance of trying to reconcile the regimes. And I won't talk about this, this gets into questions of treaty interpretation. But I mean, basically the fundamental approach to treaty interpretation, kind of rule number one, if you have two treaties that are kind of covering the same issue area, is you try to find the answer that is consistent with both treaty regimes and doesn't violate either. And when it comes to this particular example, we can see that detention en masse clearly violates human rights law. It's not mandated by drug control law. So therefore, the actual legally correct answer in an interpretive approach is voluntary treatment, not in closed settings. Sorry, that was an awful lot to pack into 30 minutes, so I apologize if your heads are spinning a bit. But I'd be happy to take any questions of what I might have skipped over, so thank you.
minutes for questions and some answers.
Well, two questions. The first one, when you talk about human rights and drugs, we have many fields to work on. Maybe first one could be the liberty of the as such and how the individual decide to consume drugs, for example. The second one could be health, public health. And the third one could be the environmental health. It seems like you have focused on the second one, the health problems with mass detention and everything. So my question would be, why did you decide to choose that topic? And do you consider nowadays is it more important than the other ones? And you can see from the like a general perspective, try to encompass the rest of the problems. And the second question would be, if you have had the chance to check the new process which is carrying out in Uruguay related to legalization of drugs, and how do you see what is your opinion about that new process?
Yeah, I mean, for this particular, I mean, first of all, you're totally right. I mean, you can look at human rights as they intersect with drug control in 100 different ways. And this is only one particular approach to one particular issue. I chose this looking at kind of the right to health and arbitrary detention aspect, specifically just to illustrate as sort of an illustrative example of how to use the sources. So it's not, there's lots of other ways you can look at this particular issue. I was just trying to look at ways to show how you can use the sources from both areas of law in a way to kind of answer some basic questions. Is that? Yeah, I said there's obviously other areas that you could look at, and there's many other areas of human rights and drug control, or environment and drug control as well, as you said. That's not my area. There's loads of issues related to environmental protection and drug control, which can be a whole other area of endeavor. In terms of Uruguay, I mean, Uruguay is just legalized, well, essentially Uruguay has nationalized the cannabis industry. And I mean, there's a fair amount of debate going on about this at the moment. I mean, essentially what Uruguay has done puts them in breach of the international drug control system. They argue that they're not in breach, which is fine. But I mean, I don't think there's anything wrong with being in breach. I mean, if you think it's a bad law, then I think there's nothing wrong with breaching a law as a form of civil disobedience. Certainly Uruguay's rationale, as I understand it, for their new cannabis policy is very much about, as a human rights element to why they're doing it, particularly around right to health and increasing public security by trying to reduce criminal markets. So I think I totally support it as an experiment in law. I mean, it does violate the drug convention. I'm going to say the drug conventions, I think at this point in time, are under a fair bit of scrutiny about where they're going to go. And clearly those kind of experiments, I think, are going to happen. It's even happening in the United States as well, obviously, although Uruguay's model is completely different than what they do in the United States.
Rick, can I jump in there? So what's the difference between a country like Uruguay saying, oh, well, there's a problem here, so we're going to violate the drugs convention? You say, well, that's fine, there's a law they don't like, so to speak. Well, why should another country do the same the other way around and say, well, we're going to violate human rights because the drug convention is more important to, according to that reasoning, what's the difference between the two?
No, this is actually the debate we have within the sector, because within our sort of little sector, the drug reform sector, there's one sort of line of argumentation that we should say it's not a breach and just pretend it's not a breach and support the policy reform. My approach is that, well, it's obviously a breach. So there's one of two things you can do. You can either withdraw from the convention, which would be my probably preference, which I say withdraw from the convention and voluntarily, I mean, there's a whole other area of that, but you can voluntarily subscribe to some of the, I think, the quite sensible areas of the drug conventions around. Most of the drug conventions are like commodity control and controlling importing and exporting of, quite sensible sort of safeguards. So one thing you can do is withdraw from the convention and cooperate voluntarily with those systems, which I think in broader international law terms would be the preferable solution. What happens is that there's lots of other, as I found from talking to my Latin American colleagues, lots of other interlocking treaties, particularly with the US, of which being a party to the drug conventions is necessary. So in that context, the approach I've always preferred is if you're going to withdraw from the law, be honest about your breach and make your case. You know, make your case, we're doing it for this reason because we think the law is outdated and we can't withdraw from the treaty because we're locked into it for all these other geopolitical reasons. But I think, again, I mean, if one's interest, I mean, this gets into some organizations or drug policy reform or some states, if your interest is in trying to reform the treaties, then I think pretending that you're not in breach actually doesn't create any momentum towards reforming the treaties, where if states start to opt out in one way or another, but do it, I mean, Uruguay's position at the moment is they're not in breach. But I think that's...
Yeah, I was just wondering to what extent the kind of more radical approach is gaining traction, you know, because it does seem to be more and more apparent that the war on drugs and criminalizing drug use, etc., generates crime. And as a matter of fact, it generates crime, you know, more than in proportion to the effort to try and sum it up. And, you know, if one looks at attempts to criminalize, prohibit alcohol, that clearly, historically, has generated crime as well. So I was wondering, I mean, to what extent are people at the UN level actually challenging whether one should have all of these structures at all? And if, in human rights terms, you know, and if one of the fundamental principles is dignity, then the right to self-destructive, that is what one wants to do.
Yeah, I mean, there's all kinds of cracks. Well, there's a number of things, I mean, from my perspective anyway. There's a number of cracks, obviously, appearing in the international drug control regime. And we see this with cannabis legalization in a couple of countries, and the impetus coming from some Latin American states who are concerned about massive criminal gangs and the destabilization effect that has on states and violence against the population. So there's cracks in the regime that way, but there's always been cracks in the regime. So they're coming forward a bit higher. But I'm always reluctant to overstate, from my perspective, how significant those are. I think, well, I should say they're significant that they're happening. But in reality, it's a small number of countries. I think the vast majority of countries still is quite happy with the status quo when it comes to drugs. So I think there's always this question, we have to reopen the drug conventions and renegotiate them. I think that would be a bad proposition. Because I think a lot of very powerful countries are quite happy with the drug conventions and probably don't think they're restrictive enough, you know? But that said, I mean, there is interesting things going on, obviously. There's going to be a General Assembly special session on drugs in 2016. Don't know what will come out of that. You know, what's interesting now is we're seeing actually sitting heads of state start to openly question the regime. And again, it's in small numbers numerically overall in terms of countries, but again, that sort of fissures, I think, that have always existed a bit under the surface are starting to rise a bit more and come out into the open. And that can only be a good thing, even just for the progressive development of law. I think one of the things that's quite frustrating about drug control law, as I said, I spent a lot of time reading 80-year-old drug control law, is it's all based upon essentially the same premises. You know, so the law at its core elements hasn't really progressed, even as what we know about drugs has revolutionized in the last 50 years. You know, so the law hasn't really, to my mind, kept up to pace with, again, what we know about the health effects of drugs or managing drug use issues.
Thanks. I should have said really fascinating presentations.
There were two hands or just the one for the... Okay. Well,
my answer was kind of...
because I think what we'll do, if there are two,
Take
we'll take very quickly both of them, and Rick will have 3 minutes to try and respond to
Okay.
and wrap up.
Yeah, mine was really quick. I was thinking, has there been any talk within the US system about the, not maybe the values of the drug control regime, but more about the legalistic, so like, for example, there isn't much proportionality, for example, like principles that are now very well established in human rights, in the drug conventions. Have people started talking about this?
Okay, and Olivia?
My question was concerning the International Narcotic Control Board, and what exactly does it do when it reviews the compliance of the states with the conventions? Because in a way, you've showed us today that there's no conflict in both regimes. So I'm wondering if maybe it's the International Narcotic Control Board that is in breach of international human states?
Sure, yeah.
Rick, you have 3 minutes to answer everything.
Yeah, I mean, in terms of the proportionality question, yeah, I mean, that's a very, I mean, that would be a great thing to do work on. And there are people who've done some work on proportionality, and even the International Narcotics Control Board a few years ago did a big section on the need for proportionality. I mean, I've done a lot of work on the death penalty for drugs, which I didn't get into. There's obviously proportionality questions there, but it's much broader than that. So there's certainly a lot of work to do there. And that gets into the way the drug, this is one of the areas of risk of suppression regimes like the drug control conventions, but not unique to them, is if you set up essentially international activities that are criminalized, a class of activities, and then you defer to states and turn it over to states to use their own domestic laws to essentially criminalize those activities, but without any human rights guidance. This is where you see a lot of the human rights abuses happening, is how states are interpreting those international sort of criminal obligations. So proportionality comes across generally in suppression conventions and absolutely in drug control conventions. So if you wanted to write on that, that would be really good. The INCB, International Narcotics Control Board, it's similar to the UN treaty bodies. It's a body of independent experts that are appointed in various ways. Some are states appointed, some are recommended by the World Health Organization. When they go to countries, they're not very open in what they do. They're not like human rights treaty bodies, where the whole process is the open and the country report is available online, and NGOs and civil society can come and make depositions. It's very secret. It tends to happen behind closed doors. And they basically focus, and this is one of the critiques of the International Narcotics Control Board, is they tend to very much focus on the enforcement end of the conventions to the exclusion or the detriment of the health base. Because there are some health-based obligations within the drug conventions as well. Provision of access to essential medicines being a key one. And there's often criticism, I think quite fairly, that the focus of their country visits is on, you're not controlling precursors this enough, or your laws on this are too weak, or, you have, some very punitive and law enforcement-based critiques, rather than saying, well, most of your population can't get access to pain medication when they go to hospitals. What's wrong with that? So there's certainly elements, I think, where the International Narcotics Control Board is not fulfilling its mandate. But that said, it doesn't have, its mandate is a bit more restrictive than what we might see as some of the human rights committees. They can't take individual complaints, thank goodness. We wouldn't want to take individual complaints. They're basically sort of just a very basic monitoring system. And the largest technical part of what they're supposed to do is kind of oversee that commodity exchange aspect that I didn't really talk about, like the importing and exporting and the licensing of medicines or controlled drugs between countries or within countries. That's a large part of what they do technically. And their country visits kind of focus a lot on that. But to the degree they comment on stuff, it tends to be on the law enforcement end rather than sort of the health end.
Okay, so I think you've seen in terms of this topic, I mean, we really were just scratching the surface here. And hopefully that at least gave some idea of the complexity of the issues that we're dealing with. So if we can just thank Rick from
We have these two for us.
that's the journal, by the way, that you can all take a copy. So just thank Rick for more information also, if you like, is on the website of the Center for Human Rights and Drug Policy.